Greetings, everyone, and thank you for joining us this afternoon for the Metropolitan Black Bar Association's Labor and Employment Committee's webinar, COVID-19 Navigating the Workplace Impact, Part 2. My name is Tanya Blocker, and I am a co-chair of the MBBA Labor and Employment section, along with Dominique Seyfarth, and our secretary is Ephraim, Pierre. For this particular webinar, I do want to just go over a few housekeeping and administrative matters. The first being, this is a CLE webinar, and thus I will be providing throughout the webinar a CLE code that you will then use subsequent to the webinar to input to receive your CLE credit. The MBBA administrators will send you an email after this webinar whereby you will be able to utilize that code. Second, our speakers on this particular panel for this webinar, as well as all of our webinars, are not providing their firm or respective employer's official stance on this COVID-19 pandemic, but rather they are experienced practitioners in the field and thus will be speaking from their personal experience in being experienced litigators in the area of labor and employment. Without further ado, I'd like to introduce my speakers for this webinar. We have Alnisa Bell, who is a partner at Seyfarth Shaw, as well as a member of Seyfarth Shaw's COVID-19 task force. Our next speaker will be Cassandra Labbees, who is a member of the firm Epstein, Becker, and Green. Cassandra is also a member of Epstein, Becker, and Green's COVID-19 task force. I want to take this opportunity to also congratulate both Alnisa and Cassandra on their recent elevation to partners at their respective firms. So congratulations to you both. Our final, but last but not least, panelist is Christopher Benz. Christopher Benz is an associate at Loeb and Loeb. He is also a New York Super Lawyers Rising Star. So we do have a very prominent panel this afternoon, and we're looking forward to learning more about this ever-evolving pandemic, COVID-19. Now, just for an overview of what we'll be covering today and part 2 of this webinar, we'll be covering the WARN Act, furloughs, reductions in force, reduced schedules, and other cost-cutting measures as a result of trying to curb the impact of COVID-19. We are doing an extension of the CARES Act on this webinar as well, which we covered in our last webinar, but the focal point for the CARES Act will be implications on 401k plans and group healthcare benefits. And finally, we will be covering New York State unemployment insurance, paid leave laws, sick leave, disability, and other employment benefits as a result and prompted by legislation as a result of this COVID-19 pandemic. Without further ado, Alnisa Bell will be our first presenter. Alnisa?
Hey, Tanya. All right, so, obviously, as Tanya mentioned, this is a very challenging time. It's a very challenging time for employers and as well as for attorneys in providing advice and counsel to them as they're navigating this very, very difficult time. And I can tell you that small employers, medium employers, large employers alike are all grappling with these issues, and we see all of them making very challenging and hard decisions about whether to lay off or to do furloughs or whatever they need to do to protect their businesses, as well as keeping in mind the impact that it has on their workers. So this presentation, I'm going to give you a background on furloughs, but it's going to be more of a practical sort of considerations of things that I've been seeing and things for you to keep in mind if you are having these conversations with clients, okay? So what is a furlough? A furlough is an involuntary temporary period of time off from employment. It can also be a reduction in hours. So when we look at a furlough, we think of these people, the workers, will be able to return once the business needs change and the business sort of gets back to normal to a certain extent. That differs from a layoff, obviously, because a layoff, you're terminating somebody's employment without the thought that they're supposed to return if the business gets better. Okay. Next slide. Furloughs are time off of work without pay. We're seeing more and more of those on the rise. The challenges with furloughs are really when it comes to exempt employees, so we want to keep that in mind. Exempt employees are employees where the FLSA doesn't apply to them, right? So they're exempt from those sort of wage considerations. What makes it challenging is that exempt employees have to be paid a weekly salary, right? So they're supposed to get paid $684 per week. So if they're being furloughed, you want to make sure that those employees are still getting their $684 a week. So if you're going to furlough them, you probably should furlough them by weeks and not days, because if they work, say, Monday of a week and don't work for the rest of the week, they're going to still need to get paid that $684, right? Because that's what's required for an exempt employee's salary, at least a minimum of $684. So you want to furlough them based on weeks, so maybe they work 1 week and then they're off the next week, or they work a couple of weeks and then they're off, X amount of weeks thereafter. You want to really do it on the weekly thing in order to make sure that you're still compliant, that they're getting paid whatever the weekly wage requirement is, which is the $684 per week. And so consideration for folks like that is you want to make sure that they don't have sort of access to, like they're not going on the internet and communicating about business or using their phone and things like that, because you don't want to get yourself into a sticky situation where you have exempt workers who are supposed to not be working for weeks and they're actually still performing business, because then you you will have to compensate them for that time. So keep that in mind. Those same considerations don't really come into play for non-exempt workers because they're getting paid for the work that they do. And so you really have to be mindful of the salary basis test, is what it's called, for exempt employees. Okay, so reasons why we're seeing employers looking into furloughs as an option is it really avoids cutting into the bone, and there's sort of immediate sort of economic benefit because you're getting rid of having to pay a certain amount to your workforce, with the hopes, obviously, that they get to come back, but you see an immediate benefit there on sort of the cash that you have to put out there. And there's also this sense of a shared sacrifice. When you're furloughing people, you want to make sure that you're furloughing sort of different people within the organization. So there's that sense of, it's not just maybe the lower level employees who are having to be furloughed, but it's really sort of hitting across the organization. Okay. There's also business stimulus incentives with the CARES Act. We know that the CARES Act provides a certain amount of loan and relief to businesses who are struggling with meeting their payroll, paying their rent, and things of that nature. And there's also a loan forgiveness portion of the CARES Act. So if you keep your employees on the payroll and keep them paid, that loan could eventually be forgiven. So there's a lot of sort of incentive to sort of keep people around for companies, especially those small business owners. Unemployment benefits is another consideration, because now if you're an employee who has been furloughed, you do qualify for unemployment benefits. Most states, it's sort of the 26 weeks. It varies state by state. But under the CARES Act, there's also the additional $600 on top of that benefit. So that's something that would be helpful to employees who have been furloughed, and they have that option to seek unemployment as well as the $600 added on benefit through the CARES Act. Next slide. So other considerations. If you're furloughing people, you want to look at their employment agreements and offer letters. If you have folks who do have employment agreements and say their employment agreement says that they have to be employed for X period of time, you want to be mindful of that. Maybe enter into another agreement so you're not, you don't have extra liability there for breaking an employment agreement. So you want to make sure, you want to look at the offer letters and look at the employment agreements and see what they say. You want to look at your severance plans and see whether or not furloughing someone would trigger severance. So you want to be able to review those. We talked about sort of minimum wage considerations. If you're dealing with federal and state public contractors, you want to look at the state and federal contractor laws with respect to prevailing wage to make sure that you're in compliance with those. We talked about you want to avoid fluctuations in pay for exempt employees. Remember, we talked about exempt employees. If they're being furloughed, they still have to have that $684 weekly salary. So you want to make sure that when you're furloughing those folks that you're doing it in accordance with the law. You want to also consider if there are any immigration issues. I'm obviously not an immigration lawyer, but those are sort of important considerations if you have to notify immigration because, you know, companies is backing somebody's visa. Those are other sort of considerations that you want to look into. Federal WARN and state mini-WARN laws. That's another thing that you have to sort of be mindful of. The federal WARN law, it's a worker protection law. It applies to employers with 100 or more full-time employees. And it says that these employers have to provide 60-day calendar notice when there's an employment loss that occurs due to a plant closure of at least 50 full-time employees at a plant or a mass layoff, which is an employment loss of 500 full-time employees or 1/3 of the workforce. So you want to be mindful of that because if you have a layoff that is more than 6 months, that's not going to trigger WARN. But if it's less than 6 months, it's not going to trigger WARN. But one that is, it could potentially trigger WARN. So you're going to have to provide that notice. And so you want to be sort of mindful of those things when looking at furloughs. There are exceptions to the notice. So if it's a natural disaster or unforeseeable circumstance, then notice is not required. But that's a fact-specific inquiry that the court will consider. And so the court will look and see whether or not sort of COVID would count as a natural disaster or unforeseeable inquiry. You don't want to you want to be able to deal with those issues at the forefront instead of dealing with it when it becomes litigation and seeing whether or not, you know, a company provided the proper notice. So be mindful of that. A lot of states also have what we call mini WARN requirements as well that tend to be much more stringent than the federal WARN standard. So, for instance, with New York requires 90-day calendar notice. It applies to employers with FUS 50 employees, whereas we just talked about the federal is 100 full-time employees. And so you want to be mindful of that. If anybody deals with in New Jersey has its own, which was supposed to, it's already had it, but New Jersey's needs some amendments to its WARN, and those amendments were supposed to go into effect in July 2020. And those in New Jersey, it was 90-day notice, as well as 1 week of pay for every year of service. So New Jersey actually was going to give severance. So that's something important to know. And then if a company doesn't provide the 90-day notice in New Jersey, then it's 4 weeks 4 weeks of pay for failing to provide proper notice. So there is something that's percolating within the legislature within New Jersey dealing with this, if you have companies that are operating in New Jersey that are thinking about furloughing and they meet the requirements under New Jersey law to provide that notice, you want to be mindful of what's going on in the legislature now, because at least the severance part hopefully might change, because it's going to be disastrous for companies. I mean, imagine having to pay 1 week of severance for each year of work for each employee that's being laid off. And I mean, obviously, and then there's that penalty of the 4 weeks pay if the person does not, if the company doesn't provide the proper notice. So be mindful of that and on the lookout for that in New Jersey. Okay. Next slide. So what we're seeing, some companies are doing still with furloughed employees, they're still remaining eligible for benefits. We're seeing companies are paying both the employer and employee portions of health insurance premiums. We're seeing employees obviously being able to use their PTO while they're on furlough. Some states may require companies to pay out vacation time when an employee is furloughed. So be mindful of what the state law says on this point as well. Because employees are not getting paid, there's no 401k contributions. So those are just some considerations that I'm seeing companies do during this time. Next slide. We talked a little bit already about furloughed employees being eligible for unemployment in most cases. The CARES Act providing the additional $600 payment on top of the 26 weeks of unemployment that's offered in New York, at least, and in New Jersey. You have to check your particular state to see how many weeks of unemployment is allowed. Next slide. All right, so you want to think about the business reason for the furlough in a particular department. You want to look at what the employee's primary job function is. If the employee is, if they can't perform their work remotely and they're not essential to the business per the applicable stay-at-home orders that are all going around, then they might need to be furloughed. So you want to look at that from an objective lens. If you have somebody whose work stream has been completely diminished, that might be somebody that you would want to furlough. Next slide, please. You want to make sure that your decisions are made based on objective, reasonable criteria. So you want to focus on the position, not the person. What roles do you need? Which roles have a diminished work stream? What skills are necessary to perform the work in the interim? Does it make sense to furlough everyone in the same department or with the same job title? If yes, this makes the selection process easier. There's less risk. You have an objective criteria that you're setting for why you are furloughing certain positions. Next slide, please. Okay. If you're choosing between multiple employees in the same job or with the same title and position, you want to apply the selection criteria objectively. Okay. Types of criteria that you probably should use in making that consideration. Look at the tenure that person has had with the company. Look at their tenure in their current position, their skill set as compared to other employees, the specific skill set that you need in order to do the job, their recent job performance. That's all important things to look at. How are they performing? You know, if you have two people that have the same qualities, job title, position, what makes them different? And if you have somebody that's a poor performer, well, that person you might want to furlough over the other person. So those are objective, legitimate business reasons, considerations that you can look at. Impermissible, the next slide, considerations. Of course, you never want to consider anything that's not based on a legitimate business reason. You don't want to consider someone's race, ethnicity, gender, or any other protected characteristics. You don't want to consider whether an employer requires an accommodation to do the job, right? So you don't want to say, well, I'd rather furlough X person because they require an accommodation, and that's going to be too difficult for the company to deal with at this time. That's not a legitimate reason. Okay. Next slide. I mean, and obviously, all decisions should go through an expedited legal review if the company is able to do that to make sure that everything is in compliance with state and federal laws. There's a lot of little things that we sort of touched upon just very broadly, but you want to make sure that there's compliance based on those laws, and you want to make sure that the company ultimately can articulate why it made a particular selection decision so that those decisions aren't able to be challenged. And so that's very, very important. And it's also to keep in mind that these are very, very, very difficult decisions, as I started to say in the beginning, and very challenging for companies as well as workers who are dealing with these issues.
Thank you very much. Alnisa, do you have one more? Did you have something else to add?
No, I'm finished.
Okay, great, perfect. Thank you so much, Lisa, for that. And our next topic is COVID-19, the CARES Act and Employee Benefits Plan. And Cassandra Labbees, take it away. Cassandra?
Hi, sorry, I had to mute myself.
Not a problem.
So with the COVID crisis and all the changes going on in the employment landscape, a lot of questions started bubbling up in the employee benefits scape. And so with the FFCRA and the CARES Act, and even with just initiatives being implemented by employers, you started seeing a lot of things touching upon employee benefits and the use of benefit plans in order to make specific changes. And so one of the first things that were really being brought up in the forefront when we were talking about mass testing and payment of mass testing is the cost, and who would be bearing the burden of that cost. Would that be participants through cost sharing in their plans? Would that be the employers? How much would these tests cost? What if it turns out that they don't test positive? Does that mean that the costs aren't covered under their group health plan? And so you started seeing some states and even some insurance carriers saying that they would not be charging for COVID testing, and a call for a more nationalized approach when it comes to what these costs were and who would be covering it, especially when it comes to high deductible health plans and HSAs. There's specific rules in terms of how cost sharing is applied in those type of benefit plans and whether or not they can be applied against the deductible or whether at a discount without disqualifying the HSA. So the FFCRA basically provided that plans must provide COVID diagnostic testing without cost sharing or prior authorization, kind of eliminating some of this uncertainty whether or not these testing and the diagnostic testings would be covered. And then the CARES Act expanded this and added like a broader range of diagnostic testings that must be covered without cost sharing under a group health plan. And so that includes not only your traditional COVID testing, but also antibody tests whenever that would have been developed. And I know we are starting to have these conversations about antibody tests. So that would be covered. In addition, plans would have to cover testing if individuals have signs or symptoms compatible with COVID-19. Because the symptoms are so broad and so aligned with other types of respiratory illnesses and just general flus, the concern was that plans wouldn't cover if an individual tested negative and it turns out they have a flu or they have just a regular bronchial infection. And so now that must be covered by group health plans. In addition, these laws basically said that these tests must be reimbursed at either a negotiated rate between the provider and the plan, so whatever rates that they normally would cover for other types of testing, or if they don't have a negotiated rate, the provider of these tests must post the rates, the cash price of these tests on their public website. And so that way plans know how much the maximum amount that they would be required to pay for these testing. The concern is that because of the demand for the test, they didn't want any like extreme price gouging in this area where plans were unaware of how much it truly costs and have to shop around and, delay the need of individuals to get testing. States may impose additional requirements, and some states do impose additional requirements when it comes to COVID testing and requirements, especially when it comes to insurance carriers. So if you are an employer with a fully insured plan, your insurance carrier is required to follow state mandates under state insurance laws. So those plans might have additional requirements and concerns. The insurance carriers should be working with like state insurance boards to ensure that they're implementing everything as required under the individual state rules. Next slide, please. So in addition, the FFCRA and CARES made clear that screening and testing may be done through visits to health provider offices, telehealth visits, urgent care centers, emergency rooms, so expanded where individuals can get the test. And I'll be talking a little bit about like telehealth and the huge explosion and expansion of telehealth services in this arena as a result of the crisis. There are specific rules under ERISA when it comes to those provisions and changes in group health plans and changes in benefits. But because of the extreme speed with which we're moving in this area, the general advance notice requirements just can't be implemented at this time. And so the DOL recognizing this and recognizing that employers just can't provide, they don't have 60 days that they generally would have to update an SBC and let individuals know that the summary benefits of coverage will be updated. They released FAQs last week, and in the FAQs, they said this kind of advance notice requirement is not, it's not required at this time for mid-year changes. Instead, the notice just needs to be provided as soon as reasonably practicable. So they don't define what that is, but the general assessment is that, you can make the change, and then soon after making a change, you just provide notices to employees, letting them know that changes have been made. In addition, the FAQs make clear that employee assistance programs, generally, there are specific rules when it comes to employee assistance programs in terms of whether or not they're group health plans, and even if they are group health plans, whether they're accepted benefits for the purposes of like ACA rules and HIPAA rules. In order to be accepted benefits, and most EAPs kind of try to fall under the accepted benefits umbrella, they can't provide benefits that are significant in the nature of medical care. Well, the DOL's FAQ makes clear that diagnostic testing as a result of COVID and all that blood work that might come as a result of COVID can be done through an EAP without running afoul of accepted benefit rules. And this is important because a lot of employers design their EAPs to operate outside of their group health plan, their general group health plan. So an individual need not be a participant of the group health plan in order to participate in the EAP. And so the employees generally is offered to all employees and their dependents and their spouses. And so the idea is that everyone would have access to diagnostic testing and not necessarily only individuals who are participating in the group health plan space. Next slide, please. As a result of specifically the CARES Act, a little bit FFCRA with the CARES Act really expanded it. We saw the explosion in sorts of telehealth services and what plans can do and how they can operate. And so the CARES Act implemented this temporary safe harbor that now allow plans to provide telehealth services without cost sharing under a health savings account high deductible health plan until December 31st, 2021. So it's a limited exception and it expires at the end of this year. But the idea is that it's not limited to COVID-19 testing, which is huge. So individuals can use their telehealth or remote services in order to get, regular diagnostic services or screenings with their doctors without worrying about whether or not it has to apply against their deductible before the cost sharing, before having no cost sharing. In addition, the DOL and the FAQs really recommended to states that they would start reviewing their state licensing laws in order to expand telehealth and remote care services. And so you see, a lot of states, even before this, but now, especially after this guidance, are really working to try to see how far they can expand their licensing to allow telehealth vendors to operate in the state so that individuals can have access to care during this time. Since, people are stuck at home. And the idea is we want to limit the spread. And so we want people to be able to have access to their doctors without fear of waiting in an emergency waiting room or an urgent care center or even their local doctor's waiting room and possibly contracting the virus. Same rules when it comes to mid-year changes. The regular notice requirements aren't required at this time. Instead, the notice just needs to be provided as soon as reasonably practical. Next slide, please. In addition, the CARES Act also expanded some of the expense reimbursements that are allowed to be paid by flexible savings accounts, health savings accounts, and HRAs. Generally, prior to the CARES Act, over-the-counter drugs could not be reimbursed by your flexible spending account or HSAs without a prescription. That's now you can have, like, you know, your Tylenols and your Theraflus and all of those products be reimbursed by your FSA and HSA. And in addition, they also allow now the reimbursement of menstrual care products by these pre-tax accounts. There's no end date. This is one of the few provisions in toxic benefit plans that don't have an end date. And so this is one of those things that it will go on forever. So even next year, hopefully, you know, we're getting out of this crisis, you will still be able to get a reimbursement under your FSA or your HSA for these type of expenses. And so this starts applying to all expenses incurred as of January 1st of this year. Next slide, please. In addition to all of the myriad of changes impacting group health plans, the CARES Act really started impacting, you know, having changes for retirement plans. And so one of the first changes is, you know, distribution, the ability to take special hardship distribution out of your retirement plan, your 401k plan generally, for if you're a qualified individual. So usually plans have like general hardship rules with specific limitations, but this one really applies for COVID and COVID-19 individuals and individuals impacted by COVID-19. So in order to be a qualified individual, you must be a plan participant who tested positive for COVID, who has a spouse or dependent who tested positive for COVID, or you've experienced some adverse financial consequence due to COVID as a result of being quarantined, furloughed, laid off, working a reduced schedule, or unable to work due to lack of child care. The limit under this distribution is $100,000. So you're allowed to take $100,000 out of your plan account, your vested plan account, in order to, as a result of being a qualified individual. And it also waives that early tax penalty under the code, that 10% tax early withdrawal penalty. What's different here is that the CARES Act also allows individuals to repay back that money within 3 years of the date of withdrawal. And so if an individual, let's say, takes $50,000, because there's always concern about, are people ready for retirement? And individuals are taking monies at the bottom of the market as a result of COVID-19. What's going to happen when it comes time for them to retire? They're allowed to repay back that money within the 3 years after taking it out. Plans just need to rely on an attestation by the individual that they are impacted by COVID in order to give them the distribution. If a participant doesn't meet the requirements to be a qualified individual, they might meet requirements under just general hardship distribution rules that allows them to take out some of their funds and use that for, you know, expenses as a result of certain expenses as a result of the emergency. Next slide, please. In addition, the CARES Act also expands loan rules under retirement plans. And so now a plan may increase the maximum loan amount that an individual can get if they're a qualified individual. And so that's $100,000 or 100% of the individual's vested account's balance, whichever is lower. And so plans can amend their plans, or plan sponsors can amend their plans to allow for this benefit. This only applies to loans that are being made between March 27th of this year and September 23rd of this year. So it's a very limited period of time. In addition, though, the CARES Act also has kind of created this 1-year delay for loans that are already outstanding. So if an individual had a loan now as of January 1st of this year, they kind of allow them to delay payment for 1 year, kind of to reflect the economic crisis going on right now and the inability for individuals to repay the loans. Usually you're paying it through your payroll if you're an employee. So they allowed for a delay for 1 year of the payment, and then that delay does not go against the normal maximum 5-year period under our plan. Next page, please. Another change under the CARES Act is a temporary waiver of required minimum distributions for for all plans, not only limited to 401k plans. So there are specific rules with regards to when plans should start paying out account balances. And so it's usually April 1st of the year following an individual reaches age 72. And that age 72 has just been increased. The Secure Act increased that from 70 and a half. So it used to be 70 and a half. And so now the waiver says that basically for this year, plans don't have to distribute those funds if, for instance, a lot of plans and record keepers are dealing with trying to make other changes to kind of ensure that individuals have access to funds. So if they don't get to make those distributions in 2020, that is fine. They have this 1-year waiver and they won't be penalized, and it won't be like a qualification error or operational error under the code. Next slide, please. There's also funding relief that was provided in the CARES Act for for defined benefit plans. And so there are specific rules in terms of like required minimum contributions for defined benefit plans and funding limits and requirements and penalties that can attach. And so basically for VB plans, they're allowed to delay the required minimum distributions and not make those contributions and not make those contributions as of January 1st, 2021. But when they make those contributions, all interest calculated will also need to be deposited in the plan at that time. It also allows plan sponsors to kind of rely on 2019 funding percentages instead of 2020 to kind of give them a little bit of relief. In addition, the CARES Act has provided the DOL the authority to delay filing and appeal deadlines under ERISA. There's specific rules in ERISA in terms of when plan filings like Form 3500 are due and like claims and appeals procedure. The DOL has yet to release any guidance in this area, but the IRS has released some guidance when it comes to delays impacting certain Form 5500s for those due on or after April 1st, 2020. So that means those Form 5500 filings are now delayed and they're not due until July 15th, 2020. Next slide, please. In addition, there's been all this chatter about student loan repayments and how the CARES Act has been impacting that. But one of the things that hasn't really been discussed in these conversations, education assistance plans. These are run under Section 127 of the code, and there are specific rules in terms of like how these plans are designed and who's eligible and how employers can reimburse for certain education assistance costs for their employees. And so the CARES Act expands the current rules to allow employers to cover certain pre-existing student loan debt. So prior to this expansion, employers can only provide payments for educational expenses an employee incurred while employed with the employer or on leave from the employer. So it applies to certain qualifying student loans, but the general rules under Section 127 still apply. So it must be subject to a written plan. The cap of $5,250 still applies. There must be reasonable notice provided to employees that benefits exist. The payments to the lender, the reimbursements to the student must be made by January 1st, 2021. So there is an expiration date on this, though there's been a push by some employers to have this kind of be like the law of the land when it comes to the code, because they think it would be very helpful for recruitment and retention of employees. And employees who receive any reimbursement as a result of an education assistance plan can't go and try to take a deduction in their individual tax returns for the amounts that were reimbursed. Next slide, please. So, we have all these laws that are coming out impacting benefits and trying to help employers help their employees because of the crisis. But at the same time, employers are also trying to think of other benefit strategies to assist their employees during this time. So Alnisa talked a bit about continuation of coverage, like providing health insurance for individuals who are furloughed or laid off. But we also have employers talking about just qualified disaster relief payments, leave donation programs. So if you have employees who have a huge bank of leave, creating a program so the employee can donate their leave to those impacted by the crisis, and the individual who's donating that leave won't be taxed. There's specific rules in terms of who's taxed in leave donations, so it has to be designed properly in order to ensure that the donor isn't being taxed for their good deeds. Some employers have been talking about, especially for essential workers, creating taxable stipends for childcare and elder care. And so giving a pool of monthly for individuals, and yes, it would be taxable, but to aid them, because individuals who are on the front lines, whether they're delivery persons or hospital workers, allowing them, giving them some extra assistance because they're paying for childcare while trying to work. And also pre-tax commuting assistance, like New York City and Jersey, they have like pre-tax rules in terms of like how employers are supposed to allow individuals to use pre-tax monies to purchase or pay for transportation costs. But some employers are going above that, especially in localities where they're not required to comply with it. So working with vendors to allow individuals to kind of lessen their tax burden during this time. Next slide, please. In addition, other benefit strategies, reimbursement of home office expenses, everyone's working from home, so some employers are trying to make this a little more manageable for their employees, so giving them kind of just say, hey, you have X amount of dollars, purchase a monitor or purchase an ergonomic keyboard. And this is outside of like mandates under the ADA where they might be required to accommodate for certain individuals. Their employers talking about death benefits and complying with death benefits, providing death benefits for employees who died. So their families get like a pool of money as a result outside of a life insurance policy. And so that's something some employers are talking about. And just like charities, some employers have their own foundations that they created either under 9/11 or because of Hurricane Katrina or other natural disasters, and using their foundations to kind of provide support to their employees. Next slide. Finally, a lot of people in the benefit space are talking about what is the guidance that's still needed from either the IRS or the DOL or HHS, or even not the guidance, but what could, if we have a phase 4, what could phase 4 look like? And so some of the things that employee benefits, lawyers and practitioners are talking about are like, we need additional guidance and changes when it comes to cafeteria plan election. So some employers are allowing special enrollment periods for individuals to enroll in group health plans because of the crisis. They don't necessarily have the opportunity to get that pre-tax benefit under the cafeteria plan. So allowing that to happen, some guidance there would be helpful. ACA release. We know there are specific rules when it comes to employer shared responsibility requirements and penalties that are assessed for failure to comply with the ACA, so relief from those mandates at this time, and just further suspension when it comes to pension funding requirements. Employers are saying that they just can't afford to make contributions, especially in the multi-employer space, so additional guidance would be needed at this time. And that's it.
Thank you so much for that, Cassandra. A very thorough presentation. And fret not, I am very green when it comes to employee benefits and 401k plans myself, but all of our panelists have agreed to volunteer some of their time to the extent you have questions post this particular webinar. Their information will be shared with all attendees, as well as the PowerPoint presentation. So just so you know, and thank you very much for that thorough presentation. Next, we have Christopher Benz, Loeb, who will be covering leave and unemployment benefits. Chris, take it away.
Thank you. So I'm going to discuss the leave and unemployment benefits. If we can go to the next slide. And basically, a lot of the conversation is going to be geared towards the federal benefits, because the New York State benefits really work in conjunction with the federal benefits. So the federal government's really the driving force behind the various leave and unemployment benefits that have been implemented since we've all sort of encountered this crisis. Can we go to the next slide, please? So from the federal government standpoint, with respect to sick leave and family leave, the Congress enacted the First Family Coronavirus Response Act, and it impacts sick and family leave in two ways. First, you have the Emergency Paid Sick Leave Act, as well as the Emergency Family and Medical Leave Expansion Act, which expands the existing FMLA, Family and Medical Leave Act. We go to the next page. I'm gonna first just get into the emergency paid sick leave. So the employer has to provide sick leave for full-time employees up to 2 weeks, and for part-time employees, the equal number. Oh, sorry, I didn't realize that my slide did that. So, well, I guess we'll get through it. Oh, there we go. So part-time employees, you have to pay them the number of hours that they would normally work over a 2-week period. And workers that are under a multi-employer collective bargaining agreement, they're also covered under these new laws. With respect to the sick leave, it doesn't matter when you have started working for this company. It appears that Congress really wants to take into consideration everything that's going on. If somebody just started a job, you know, they might be out of luck with respect to what's going on now. Can we go to the next slide? Just click it. Yeah, there we go. So the way they've created the eligibility requirements can really be broken up into 2 parts. Sick leave with respect to coronavirus as it relates to the individual employee, and sick leave as it relates to the individual employee's need to care for someone else, right? So we have, you're eligible if you're subject to a quarantine order, you've been advised by a healthcare provider, or you're experiencing symptoms and seeking diagnosis, right? Those are the qualifications for the personal employee. Now, with respect to caring for others, if you have to care for someone who's subject to quarantine order, or you have to take care of your children because the school or the daycare has shut down because of the precautions with respect to quarantine, or the sort of catch-all if there's similar conditions with respect to covering, to taking care of someone. We go to the next slide, please. We just click them all out, yeah. So because the brackets are broken up in the way they are, if sick leave with respect to the individual employee, there's a maximum amount of $511 per day, which comes to about $5,000 total. And when you're taking sick leave to take care of someone else, there's a max of $200 a day, and it comes out to $2,000 total. With respect to these leave provisions, employers don't have to carry it over, but they also don't have to require employees to take their personal PTO or whatever they may have stocked up before taking this. One thing that I think that's important is that employers can't require employees to find replacements for their times off. That's been a subject of a lot of changes, at least in New York City recently. And of course, you can't discriminate or retaliate against someone when they're seeking to take these leaves. Now, the Department of Labor requires employers to post a notice of these rights with respect to leave. In New York, a lot of people aren't going into work because they're closed, but the law doesn't require individuals who are working, who are teleworking, they don't require their employers to post it on their intranet, but it might be a good idea for employers to do that, even though it's not required. We go to the next slide, please. So now that's the paid sick leave. Essentially, if you are having symptoms or trying to figure out if you do have coronavirus or taking care of somebody that is affected by it, you are eligible for sick leave. Now, the Emergency Family Leave Act is a little bit more specific, and it's done by amending the existing FMLA Act, and it's limited by size. With respect to the Department of Labor can exempt certain employers from the requirements if it's going to jeopardize the business. Go to the next slide, please. So here, you can provide up to 12 weeks of leave for someone who's been employed at least 30 days. and they're unable to work because they're caring for a child that's under 18 because the school or the daycare center, the healthcare center isn't operating because of COVID-related precautions. The first 2 weeks are unpaid, but the employee can supplement that 2 weeks with the paid sick leave. After the 2 weeks, you can that's when the 12 weeks starts, and then it goes to the $200 per day and the $10,000 in aggregate for the 12 weeks. We go to the next slide. Thank you. So generally, if an employee has to take this type of leave under the expansion, it requires that the person be restored to their previous position. Now, if an employer has less than 25 employees and the position just doesn't exist anymore because of the complications with the coronavirus, then that sort of job placement protection just is no longer there. And in terms of a compliance, there's a 30-day grace period, and once that grace period is over, the Department of Labor is going to enforce it in the same way that they enforce the Fair Labor Standards Act and minimum wage requirements. Next slide, please. So these federal protections, they apply to employers with less than 500 employees. The leave provisions, they're there to supplement whatever PTO an employer already has, but they're not. An employer is not. Employer can't require an employee to take the leave. However, there's flexibility with respect to how an employee can use it, so that they can supplement their income just in case they run out of days, or the leave provided by the federal government is simply not enough, depending on the type of lifestyle they've been living before this happened. We can go to the next slide, please. So these federal protections also protect self-employed individuals, and they'll be able to receive tax credits for the money that they'll spend under both the paid sick leave and the family leave provisions if they qualify for them. But the real sort of test is if they were an employee of that business, would they qualify? So for example, if somebody has an outfit, and they're a plumber, right? It's just them going around being a plumber or an independent contractor, they will be able to receive the tax credits if they'll be considered self-employed. Excuse me. Go to the next slide, please. So New York State implemented leave for employees that are subject to quarantine. And what this does is that it supplements the federal provisions. So you qualify for the New York sick leave provisions if you do not qualify, if your company does not qualify for the federal sick leave benefits. So for example, if they have 600 employees, you won't be eligible for the federal relief. Or if under the New York state law, you will be afforded greater benefits. Excuse me. So it's really there to operate in conjunction so that people are covered essentially in every aspect, whether if your employer is too large or let's say too small, if it's eligible for some of those exemptions. Also, under the New York leave laws, the laws do not apply to individuals who, individuals who are able to work remotely. They aren't eligible for the benefits under this law. And like the federal law, you cannot count leave taken under the New York sick leave laws against an employee's paid time off. There's retaliation and job protections under the New York sick leave laws. We can move on to the next slide. So with respect to the New York laws, employers that with 10 or fewer employees and they have less than $1 million in annual income, they are required to provide unpaid sick leave for the duration of the quarantine or the isolation order. Employees from 11 to 99 employees, or if you have 10 employees, less than 10 employees, and an annual income of more than $1 million, then you have to provide 5 days paid sick leave, followed by unpaid sick leave for the duration of the quarantine. And employers with 100 or more employees, 14 days of sick leave during the quarantine isolation order. And for individuals at major retailers, that's probably a good thing because they have more than 500 employees, but they'll still be covered in some way under these sick leave laws, assuming they haven't been terminated. Can we go to the next slide, please? So also under the New York sick leave law, they've expanded the definition of disability and family leave. And essentially what that does is try to cover all the bases, which necessarily wouldn't happen in normal times, right? So if you can't perform your regular duties or an alternative form of employment, you can apply, you'll be eligible under the disability definition, how it's been expanded for the New York State leave. With respect to the family leave, if you're providing care to a minor dependent that's subject to quarantine or some type of order, you'll be eligible for the sick leave laws here. Go to the next slide. I know we're running out of time. I'm trying to get through this. Bear with me. So those are the sick and leave laws. They're really there to encompass the various situations that have been happening so that people can continue to have some type of income while maintaining their employment. Now, if that's not possible, recognizing that it's just not possible for everybody, for all the companies, the federal government has instituted some unemployment benefit plans, programs to supplement that, primarily in the form of the federal pandemic unemployment compensation program. Right, so this is for individuals who are unemployed or underemployed, reduced hours. They're eligible for these types of benefits if it's related to coronavirus. And under this new federal unemployment compensation plan, you receive an extra $600 a week. I know a couple of our panelists have mentioned that today. And in addition to the regular state benefits, each state has a different sort of cost of living, so that's where the unemployment benefit figures come from. But regardless of that, you'll get an extra $600 on top. And these benefits do not count towards income when determining whether you're eligible for Medicaid or whether your child is eligible for the children's form of Medicaid, which is the Children's Health Insurance Plan. In addition to the extra $600 a week, most states have a 26-week limit with respect to unemployment. This expands that by adding 13 weeks, which will also include the $600 per week. Part of this program, which I think is really important, the states are requiring that, the federal government is requiring that the states provide some type of flexibility in the certification that they're looking for work, they're ready for work, particularly when a lot of the businesses just aren't operating right now during these times. Can we go to the next slide?
Chris, and I'm going to chime in only because
it's 2 o'clock. I didn't realize that. I'm sorry.
We are at time. No problem. And I don't mean to interrupt your presentation, but again, thank you very much. Everyone's presentation was extremely thorough. Thank you for that. And again, the slides will be made available to all of the attendees, as well as the contact information for our esteemed panel. I want to, just before we wrap up, share the CLE code, which is 1425LE. Again, that's 1425LE. And you should be getting an email from the administrators of MBBA regarding information concerning your CLE. Lastly, again, just reminding everyone, continue to stay updated with all of the guidance that's provided by OSHA, the CDC, the EEOC, the Department of Labor, and the various state similar organizations, New York State Department of Labor as well. A new executive order that came out this week that folks should be mindful of is the order for all essential workers and employers to give all essential workers face masks to wear during their shifts. So please be mindful of that new executive order and look it up on the website for the New York State Governor's Office. And last but not least, while the COVID-19 pandemic continues to be a trying time for all of us, it is our sincere wish that you will find a few moments of peace and restoration and recentering the end of this week and this weekend, and share some empathy and care for others. Thank you very much to all of my panelists, esteemed panel, as well as all of those that are listening. Until next time, take care.